Hi, good morning and welcome to our company law class this morning. So this is a continuation of where we paused the last time. Just a quick recap. At the last session, we considered promoters and pre-incorporation contracts. And the essential points to recapitulate or to remember is that before the company is actually formed, there are a number of things which may be done in anticipation of the company, which is yet to be registered or incorporated. Now, initially, the common law had a very strict position that you cannot be an agent for non-existent principal. And so therefore, if the company is not duly incorporated, it has not come into existence. So you cannot actually be entering in the transaction on behalf of such a company. So we saw the orthodox position of the common law as reflected in cases of a Kellner and Basta, and the various twists with newborn and censored and so on. Now, in our own company's law, that is Act 179 repealed, which has been re-acted essentially through Section 11 of Companies Act 2019, Act 992, we have modified the orthodox common law position so that in Ghana, it is not automatic that if you had pre-incorporation contract, if you had a transaction done on behalf of the yet to be incorporated company, that is void. No. It is permissible for the company, when it is duly incorporated, to actually adopt it, provided full disclosure, that is, all the material information are made known to the company, which has now been incorporated and wants to adopt the transaction as it were. Yeah, so let us keep that in mind. And again, we also remember that, or we learned that where the company is going to take a decision to approve or adopt the pre-incorporation contract, the promoter or the person who played a role in the conclusion of that contract certainly will have to excuse himself and all that, so that there will be independent consideration by the company. Then we also learned that where you are a promoter and, for example, you have taking advantage of your privileged position vis-a-vis the company, which was not formed at the time that you were acting to bring the company into existence. Later on, when the company is formed, you could be held to account, particularly so where you have made what we call like the secret profit, where you have taken advantage of certain opportunities which ought to have gone to the company. Now you could be held to account. And the interesting point to also remember, as we noted, is that the law of limitations does not really apply when it comes to actions or legal suit which the company may mount against a promoter. That is to say that if it takes even 50 years, 100 years, or 20 years for the company to discover that at the pre-incorporation stage, the promoter exploited the yet to be formed company, they can always go to court and demand accountability from the promoter. As we noted, a promoter is a fiduciary, so he stands in a position of trust, confidence, and utmost good faith must always be displayed by the promoter towards the yet to be formed company or affairs of it. So in a nutshell, these are the things that we learned our previous session. Now, this morning, we are continuing with what we call formation of the company, or what we call like the incorporation of the company. And if you look at the law, as I've told you, I prefer to teach company law direct from the law, and then as and when we have like some case law which are relevant in eliminating some of the provisions, we will cite them. But we have to look at the law itself, and I intend to remain true to that approach. Now, if you look at Act 992, if you can see the screen, you notice that Part B is headed Incorporation of Companies. Incorporation of Companies. So the question which would obviously come up is that, what does it mean to incorporate a company? When we say incorporation, what is the meaning of the word incorporation? So as I always tell you, if you come across a word in the legislation, you quickly check the interpretation section. If there is a definition, right? If there is a definition, or if some explanation has been given to that particular word, so that within the context of that legislation, and in this case, the Companies Act, it is a meaning which is stipulated in the interpretation section, which will be the appropriate meaning whenever that word is used in the context of that legislation. So what I did now, and I also invite you in your various homes, you can do that. You can jump to Schedule 1, the first schedule, right? Which start from page 301, contains what you call the definitions, right? Now, if you look up the word incorporation, you will not find it there. Meaning that the word incorporation is not given a particular meaning other than the meaning which the word has within the legal community, right? But we can infer meaning of incorporation from definition of a incorporated company. So look up the word company. If you go to the definition section again, that is the first schedule, right? You see company there. And this is how company is defined. So we are going to quote that definition and use that to infer or imply the meaning of the word incorporation. Good. So I'm quoting. Company means a body formed and registered under this act. Company means a body formed and registered under this act. Good. So we can say that incorporation will mean the processes or the procedures by which a company is formed and registered under the Companies Act 2019, Act 992. So that is the meaning of incorporation. All that you do to get a company formed and registered within the framework of Act 992. So let's keep that in mind. Now, having understood what it means to incorporate a company, or what incorporation means, we ask the question, who has the right to apply for incorporation? Now, can anybody at all get up and go to the registrar of companies and say that I want to incorporate? Now, in terms of section 12 of Act 992, as a general rule, a person of 18 years and above qualify to apply for incorporation, qualify to apply for registration of a company. So let's keep that in mind. And another point worth deducing or inferring from section 12 is that if it says that a person of the age of 18 years and above may apply for incorporation of a company, what that means is also that we can have a one-member company. Don't forget. I've already asked you to read the case of Aaron Solomon and Solomon, or Solomon and Solomon, as is popularly known. And if you go back to the fact of Solomon and Solomon, you will notice that under the original English legislation for general incorporation, that is the first ever general incorporation legislation in England, it was a requirement that to have a company registered, you needed, I think, 7 members. And that is why, if you look at the story, the shares were a little over 20,000, and Mr. Solomon had a chunk of it, and he gave just 111 to the other members who were his wife and children, in order to satisfy the requirements of the law at the time. Interestingly, if you juxtapose that scenario in Solomon and Solomon by our own law in terms of section 12, which we've just quoted, our law has moved away from that and says that one person, so long as he is 18 years and above, can apply for registration of a company. So let's keep that in mind. And this is also pertinent. As I asked you, we look at the sole proprietorship. Of course, I gave you the notes and I asked you to read. You look at sole proprietorship, or what they call the one-man business. It's one person. So now that's under the Companies Act, it is permissible for one person to incorporate a company. A question may arise: why would a person want to remain a sole proprietor, a one-man business, when it is permissible under the law for a one person to register a company, to have like a one-member company? If that is possible, then why do you want to remain a sole proprietor? Particularly so with all the disadvantages who go with sole proprietorship with respect to liability. As you notice, in the case of a sole proprietorship, there is no limit on his liability. There is no separation of the business from the person, meaning that the assets of the business are the assets of the person, the assets of the person, assets of the business, liabilities of the business are liabilities of the person, and so on and so forth. And where there is a problem and the person is sued, he's sued in respect of a business transaction. However, if the one who sued him is successful, he will try and levy execution, try and enforce the judgment, not only against the businesses or properties of the properties of the business of this sole proprietor, but he wants to extend it to his personal properties and so on. So obviously, these are some of the downsides of a sole proprietorship, and that is why it is refreshing that under the Companies Act, one person who ordinarily would have been a sole proprietor can take advantage of the law and get the company incorporated. So let us keep that in mind. Now, what is the procedure? How do you get the company registered? Now, before we do that, I want to quickly take you to the website of the Register of Companies, right? The Register of Companies, as you will notice, used to be part of what we call the, it used to be part of what we call the Registrar General Department. However, following the coming into force of the Act 992, that is the new Company Act, it has been decoupled, or it has been separated. It has been separated from the Registrar General Department, and the Registrar of Companies is the main body which is supposed to be responsible for registration of companies and other businesses. But you see, despite the fact that the law has decoupled it, of course, if you look at the old, so I want you to look at something closely. Now, the website I have come to, can you see the screen? Can you see the screen? Let me see. Can you see the screen?
Yes, sir.
All right.
No, please, we can see.
Okay. Yeah, so I'm clicking on the, good, you know, you come to this screen and let's go to the About Us first so that you have a good sense of what is happening. Now, where we've been to now is Registrar General's Department. Is not the Registrar of Companies. It is expected that the Registrar of Companies will have its own website, and I hope they do. So let's go there. Registrar of Companies, Ghana. They're supposed to have their own website, but it's strange they've not been able to move out, because under the new law, the Register of Companies is like a standalone entity, and we have like the Registrar General. So let's say that if it comes to registration of businesses, they have what they call the online registration. Let's click on it and see what happens. Good, okay. So I just want to play that. I just want you to look at the things here before we go back to the discussion. So they have a name search. If you want to register, you have to, the name that you want to use, you need to find out, is the name available or somebody has already taken it? Sometimes you may need to reserve a name. You've not yet finished the registration process, but there's a particular name you are interested in. So you want to actually reserve it, and no one will take it, and so on. So that is possible. So look at it. Then they have what they call like the entity registration. It's really a shame. Ghana, we're not good with using the internet effectively. So you can just go there on your own and check. But as I said, the register of company itself is supposed to have its own website. A minute. Let me share the screen. Okay, so to have a company registered or incorporated, we have to look at section 13, and it is a requirement that you send an application. An application must contain certain essential information. So the name of the company, and as we saw on the website and we discussed further under section 21, that the name that you intend to give to the company, you need to find out, is the name available? Just like if you want to set up like a website, you need a domain. You need to conduct a search to find out whether the proposed name or the domain you want to use, whether it's available. That is, no one has taken that, so you can have it. Then you need to also indicate the type of the proposed company. What type of company you intend to set up. Now, we've seen various types of companies from our previous lectures. Company limited by shares, company limited by guarantee. We've seen unlimited company. We also have public company, private company. Yeah, so you need to indicate the type of company. And again, you need to indicate the nature of proposed business in the case of company registered with an object. Now, let me say something briefly on this point. Under the old law, that is, if you look at the repeal at 179, there used to be what we called an object clause. Just as if you go to English company law, in English company law, in terms of the company constitution, they have a duality, or the two documents, memorandum of association and articles of association. And the memorandum of association, there's what we call an object clause, in which you state the purpose or the things which the company is set up to do. And that practice is the foundation of what came to be known as the doctrine of, the doctrine or the rule in the Tech One case, the indoor management room, and so on, or the doctrine of Travaris, that once you are a company and you have stated that you are going to engage in particular type of business or activities, then what it means is that you cannot go outside the scope of that. If you go outside the scope of what you said you are supposed to do, that is Travaris and so on. Now, that used to be a very strict rule, but in the course of time, it has proven to be unhelpful, especially if you look at how dynamic business environment is. There's so much dynamism in the business environment, in the sense that every now and again, various changes and developments are taking place, and you may want to take advantage of that, which has got a good value in terms of demand and supply. So therefore, if you are affiliated with a particular stated object, and you have to go back and do amendment to your company's constitution every now and again, so as not to be caught by the Travaris rule, that is really not very helpful. And that is why our lawmakers in the new Companies Act of 2019, Act 992, they have relaxed the ultra-vires rule. They have relaxed the requirement of object clause. And that is why if you look at section 13(2)(c), that the nature of the proposed business in the case of a company registered with an object, that is to say that it is not mandatory for you to register with an object with a certain stated objectives. It's optional. If the company wants to do that, it is not really forbidden, but it is not mandatory that if you don't state the object for which you are incorporating the company, then you cannot incorporate it. No. So that has been relaxed. So that is the rationale underlying section 13(2)(c). So let's keep that in mind. Another information which needs to be included in the application is the address of the proposed registered office. Address of the proposed registered office and principal place of business of the company in the Republic. In the Republic, the telephone number, the post office, private mailbag or digital address of the registered office of the company. And of course, the electronic email address and website of the company if available. Now, you may want to ask, what is the point of all these requirements? That is the proposed registered office, place of business, the digital address, telephone number, email address, and all that. Now, remember that the company is an entity upon incorporation. It's a legal person. It can sue and be sued. Now, when it comes to legal proceedings, there's what we call service. If you need to serve a process, you need to know the residential address of the person or the place of business, in this case, the company. And that is why the place of business is important. So that when documents are delivered there, the company could be deemed to have been properly be served. Another requirement, the particulars of each subscriber. Particulars of each subscriber. So we have come across a new word, subscriber. Who is a subscriber for purposes of company law? Now let's go to the definition section. That is the definition section in Schedule 1. So if you jump to page 308 of the Act, subscriber is defined there. Subscriber, quote, in relation to a body corporate means a person who applies for the incorporation of a company, unquote. So a subscriber is a person who is applying for incorporation of a company. Now, the question may arise, then what about the promoter? Of course, every subscriber is a promoter. However, not every promoter is a subscriber. So let's understand that. Because if you remember the definition of a promoter, when we were learning it under session, I think 10, when we were learning it under session 10, that session 10.1 says that a promoter is a person who is or has been engaged or interested in the formation of a company. So that is a promoter. And we have just quoted who a subscriber is. That a subscriber is a person who applies for incorporation of a company. And that is why I have indicated that every subscriber is a promoter, in the sense that he can come within the meaning of promoter as someone who is engaged or who is interested in formation of a company. If you are not interested in formation of a company, why will you submit an application for its incorporation, isn't it? And we know that subscribers are those who submit application for incorporation of the company. So that is a subscriber, according to the Schedule 1. And therefore, we can say that a subscriber is a promoter. But not every promoter is a subscriber, because a person might have been engaged or interested in information of a company in the sense of doing certain things in anticipation of that company being set up and all that, but may not get involved in the actual preparation of the application document, as in like signing as a subscriber and all that. But that doesn't mean that it's not a promoter, it's a promoter. So let's get the difference. So maybe in thinking in terms of mathematics, we could say that the promoter is the mother or the investor set, and then a subscriber is a subset of that. Another information which is required is that the subscribers, we need to know their date of birth. And you may want to ask, why? Don't forget that not too long ago, we stated in session 12 that a person who can apply for incorporation of a company is someone who is 18 years and above. And that is why the law requires that the date of birth of subscribers should be disclosed, so that we can work out whether they meet the age requirement as stated in the law. And of course, their names, residential, occupational address, their nationality should also be stated. The nationality should also be stated. Then particulars of each proposed director of the proposed company. You will notice that in Ghana, to form a company, you need a minimum of 2 directors. So even if the law allows a one-member company, the one member must get another person in addition to himself or herself to be the directors before the legal threshold can be met. So let's keep that in mind. So the proposed directors, their details with respect to their full name, formal name, particulars of their business occupation, and other directorships. That is, if they've been directors in other companies, they must also indicate it. Their residential, occupational, email, telephone numbers, and all that should be indicated. And again, as part of the application process, it must be accompanied by what we call a statutory declaration. A statutory declaration. We have explained what a statutory declaration is. The last time I made the point that there are 2 ways of making statements to be taken seriously. That is, making a statement to be taken seriously on oath. It may be done in the form of a statutory declaration or by affidavit. And I explained that a statutory declaration is used where you don't have any proceedings before court or quasi-judicial bodies. So if the statement you want to make under oath is not going to be used immediately in judicial proceeding or quasi-judicial proceedings, then you use statutory declaration. And according to the Statutory Declaration Act, it is a solemn statement made on oath, as it were, that what you are saying is true and all that. And of course, because it is a statement on oath, if it turns out to be false, you've committed offense of what? Perjury and all that. Now, so as part of the incorporation application, you have a statutory declaration by each of the proposed directors. So each of the proposed directors is supposed to make a statutory declaration and swear that what they are saying is actually true. Hello, Doc. I'm teaching. When I finish, I'll call you. I'm in Accra. I'm in Accra, so when I finish, I'll call you. Okay? All right. I'll call you after class. Yeah, so each of the proposed directors must make a solemn statement that the things they are saying are true. And what are the things that each of them is supposed to make a solemn statement in the form of certificate declaration and say? One, that he has not been charged with or convicted of a criminal offense involving fraud or dishonesty. So you must let us know, because if you have once been charged with or convicted of the offense of fraud or dishonesty, you are not qualified to be a director. Maybe the problem that I have with the law is the bit with the charge. Because if you are charged with an offense, it doesn't mean that you have been found guilty. After all, Article 19 of the Constitution talk about presumption of what? Innocence. So if someone is charged with the offense, why should you use that to create a legal disability and say that the person does not qualify to be a director? I hope one day somebody will challenge this in the Supreme Court for you to be struck down. Especially so, you can be charged with an offense and the police or the Attorney General Department may not be so much desirous of following through with the prosecution. And you have the criminal charge hanging around your neck as albatross. And it also creates a legal disability for you because you cannot offer yourself to be a director of a company. So that is the difficulty there. Now, the subject declaration must also indicate that you've not been charged with or convicted of a criminal offense relating to promotion, incorporation, or management of a company. Because if you have been convicted of you having cheated a certain company and all that, then naturally you are not fit to be a director of a new company. Then the third requirement is also that the subject declaration by the proposed director must state that he has not been declared insolvent. That is, being declared insolvent means that you became bankrupt in the sense that you could not pay your creditors. You could not pay your creditors. Your assets are just not enough to satisfy any legitimate claim against you. So you decide to seek refuge under the personal insolvency legislation. And then you get an insolvency order made that you are insolvent or you're bankrupt. And what that means is that you're not being protected by law. So people should stop pursuing you. And if that is the case, then you have no credit. You are not credit worthy. So nobody should allow you to become what? A director. And later on this particular point, you will notice that when we are discussing directors, there's a case which is called ex parte Pleutner. Somebody had been declared bankrupt in Germany, and later on, the person was made a director of a company in Ghana, and someone sought to use the bankruptcy or the insolvency proceeding from Germany as a basis for this person who is a director here to be disqualified. But we'll discuss that when we are learning about directors later on. Now, as part of the registration process or the application for incorporation, it must also be accompanied by consent of each proposed director. So each proposed director must consent in writing that he accepts to be appointed a director. So that is important because being a director has got onerous responsibility, and we want to be sure that the person freely accepted to be a director. The application must also include particulars of proposed company secretary or the proposed company. The company must have directors, we talk about that. It must also have a special officer called the company secretary, whose duty later on we learn include shepherding various governance arrangements of the company, compliance, ensuring that the company complies with all that the law requires of it, all the annual returns are filed, proper statutory documents which need to be circulated, including published and audited accounts, are made available to members, directors, and all that before all scheduled meetings, annual general meeting, extraordinary general meeting, and so on and so forth. So that is the work of the company secretary. So the application for registration must provide information about who is going to be the company secretary. And information is what is outlined there: the name, the occupation, the email address, the residential address. And also, let's remember that the company secretary need not be a natural person, an artificial person. That is, a company can also be a company secretary, if you like. You can have a company which is set up to provide a company secretary or secretariat office services. So that is also permissible. The application must also include information about the proposed auditor. The company must have an auditor, external auditor. So the details of the auditor, the name, the address, and then the consent of the auditor. And the consent of the auditor is important. And I hope you remember your law of tort. The case of Hedley Brown, Heller and Partners. The case of Caparo Dickman. Remember all those cases. Liability for financial misstatements and all that. And that is, so if an auditor, if audited the company books and you make a statement that you have examined the books according to established accounting standards and protocols, and in your considered view, the books of the company have been kept according to the requirements of the law and then the prescribed accounting standards. Full stop, you sign. Now, people place their hope, right, in this statement and make certain decisions, either to acquire more shares or some other investment in the company. And later on, it turns out that you were negligent, you didn't do proper work. And for that matter, the conclusion that you came to was not a good conclusion. And that is why the law wants the auditor to have consented, because there's responsibility, there's potential liability which the auditor may have to face. So let's keep that in mind. The application must also provide particulars of each subscriber for a proposed company with shares. So mind you, you talk about subscribers generally, right? But if the company you are seeking to register is a company limited by shares, then later on we come to to learn a principle that in a company limited by shares, each subscriber must have at least one share. That is a requirement. Now, where the company you are seeking to register is a company limited by shares, then the law requires that details of the subscribers should be provided, as we have the name, the telephone number, nationality, proof of identity, place of work, position held, and so on. And also, some shares are held, if you like, in the name of some people, but they are not the real beneficiaries. So that maybe I acquire shares in the name of one of you. Who wants me to acquire shares in his name or her name? Okay, so I acquire shares. That's a Oforiamwa. You want me to acquire shares in your name? Okay. All right.
Yes, sir.
All right. So I acquire shares in the name of Justice Oforiamwa, for example. Now, if you go into the records, his name will show as the shareholder. But in reality, he just, if you like, nominee, or he just, a holder in name. He's not the ultimate beneficiary. When dividends are declared, you have to send the money to me, put them in my account. When there's going to be election, you have to consult me so that I'll tell him whether he should vote for Mr. S or Madam Z for position of the director and all that. Now, in the old law, this particular beneficial ownership, if I say old law, I'm referring to the repeal at 179. The law was silent on it. But now that we have concern with corruption, we have concern with transnational organized crime, we have concern with illicit financial flows, all these important crimes which have assumed transnational, international dimensions, we need to go a step further and make sure that when shares are actually held and they are held for benefit of someone, we should know who the beneficiary is. And that is why it is a requirement that the particulars of the beneficial owner of shares of each of the proposed company must be disclosed. And that is very important, especially those who are into politics and other things and may want to use other people as a, if you like, a conduit. As somebody all of a sudden is acquiring more shares in the company, he comes to buy 1 million shares, 2 million shares, 3 million Ghana cedis worth of share, 5 million. Then you go and find out that the person is not really, if you do what they call like the means test and all that, he's not someone who can actually, have all that kind of money. Now, what it means is that someone is behind the scene, and the person is trying to divert probably either stolen or improperly acquired money through these means. And that is why now it is a requirement that you disclose the particulars of information about the beneficial owners of the shares. And more importantly, as part of the information of the beneficial ownership, if you look at the VII, that the nature of the interests, including the details of the legal, financial, security, debenture, or informal arrangement giving rise to the beneficial ownership. So if the shares you are holding it for on behalf of someone, we're interested in knowing how the whole relationship came about for you to be entrusted with that and all that. And then and a VII, the 8, is even more poignant. A statement confirming whether the beneficial owner is a politically exposed person. You see, politically exposed person, that is the beneficial owner. The person who is the ultimate, if you like, beneficiary of the shares which you are holding for on his behalf. Is he a politically exposed person? You must indicate. Then you may ask the question, who is a politically exposed person? If you go to the interpretation section of Act 992, so you can jump to page 307 of your law. A politically exposed person is defined as this: includes a person who is or has been interested with a prominent public function in this country, a foreign country, or an international organization, including I, senior political party official, government, judicial or military official. II, a person who is or has been an executive of a state-owned company. III, a senior political party official in a foreign country. And B, an immediate family member or close associate of a person referred to in paragraph A. So if a person comes within any of these permutations, that person is a politically exposed person. And of course, it also applies to members of the immediate family of a person who come within that permutation. He also becomes politically exposed person. So all this information will need to be disclosed. And as I said, the rationale of it is to fight corruption and make sure that people don't use companies and share ownership in the company as another ground of diverting their corruption process. The application, again, must also have the following information. If it is a company limited by shares, again, it must indicate the amount of the proposed stated capital. The amount of the proposed stated capital. So how much stated capital is actually being registered. So later on, we are learning about shares. If you go to section 68 of Act 992, we are given the technical definition of what stated capital is. And basically, it refers to the total proceeds of every issue of shares for cash, including the amount paid on cost and made on shares issued and unpaid liability, less deduction for transaction costs that are direct and incidental to the share. And B, the total value of the consideration as stated in the agreement received for every issue of shares otherwise than for cash. And then the total amount which the company by special resolution resolved to transfer to the capital from reserves. In other words, the amount of money which the company hopes to raise by shares, which it will actually issue, should be stated. That's the stated capital. And again, the number of authorized shares of the company for each class. So the company must not have a limited number of shares. The company must always have a finite, that is a particular stated number of shares, and that should be indicated. And if we have shares which are in classes, sometimes you can have preference shares, class A shares, class B shares, funded shares, and so on. Now, for each of the classes of shares, how many shares are you registering the company with? That should be stated. And if it is not a company limited by shares, but it's a company limited by guarantee, the application for registration must specify the amount of money up to which a member undertakes to contribute to the assets of the company in the event of being wound up while that person is a member or within a stipulated period after ceasing to be a member. So as you remember, when we were learning about types of companies, we said that in the case of company limited by guarantee, there are no shares. All that a member has to do is to indicate how much money he is willing to contribute to meet the liabilities of the company in the event of the company being wind up. So let's keep that in mind. So when you have provided all this information, the subscribers must sign the application. The subscribers must sign the application which you are submitting to the Registrar of Companies for Incorporation. And as I indicated, each subscriber must have, if it's a company limited by share, each subscriber must have at least one share. And the amount of money which the subscriber has paid for the share should also be stated. And if you remember the case of what do you call the Adeshaman Gardens, as well as the case of DePaul and Investments concerning who were the original shareholders, the original subscribers, and all that, and then how Justice Sufaya would make the point that a company has got certain facts which can never be changed. They are just like the DNA, the genetic markers, and these include the subscribers of the company. Just a second, please. All right, so let me get to the citation. Let me put it here for you. Paul Wood treatment against Asari, 2005, 2006, Supreme Court of Ghana Law Report. Yeah, I want you to pay attention to especially 695 to 698. 695 to 698. That is the opinion of Justice Sufaya Kufo. Yeah, so in the Paul Wood treatment against Asari, I'm just quoting a portion of the judgment. So that is Sufaya Kufo speaking. I quote. in the genesis of a company with shares, I'm quoting from page 697, right? I'm quoting Justice Vakufo. In the genesis of a company with shares incorporated under the code, there are 3 significant characteristics, in my view, may be likened to 8 genetic markers, DNA. These are the names of the first directors of the company, the number of shares of no par value with which the company is registered, and the signature and names of the subscriber to the regulation, as well as the number of shares each is taking and the amount of the consideration payable in cash in respect of such shares, duly attested by at least one witness. Unquote. So, just the same point we have here, her leadership saying that, like, the information, certain information which are required to be provided at the time of applying for registration or incorporation of the company are historical facts which cannot be altered. Of course, the application which you submit to the Registrar of Companies, you must indicate if you propose to you propose to register a constitution. And this is very important because it's not mandatory for a company to register a constitution. Now, under the repealed at 179, the language which was used was what we called regulations, right? And of course, the regulation was also a departure from the 2 separate documents, which is used in English company law. As I indicated, in English company law, originally they had Memorandum of Association and then the Articles of Association. But in 1963, when we adopted at 179, we just merged the 2 documents and we called it just simply regulation. So that was the constitution of the company. Under the current law, we have also changed the language. We no longer say regulation. We say constitution, right? So now we don't say regulation of the company. We say constitution of a company. And for now, it is not mandatory for a company to try and craft its own constitution, as it were, at the time of registering the company. But if the company so wants to do, the law allows it, but it's not mandatory. And that is why section, 12 subsection 4 is telling us that the provisions of subsection 3 shall apply to an application and incorporation of a company that proposes to register a constitution. If you are going to register a constitution, then you have additional requirement, including the fact that it should be signed by the subscriber, the shares that they have acquired and everything should be stated there, it should be witnessed and all that. Now, when you have assembled all this, what do you do? When you've assembled all this information, the various information, including the statutory declaration by the proposed directors, including consent in writing by proposed director, including particulars of the company secretary, including particulars of the auditor and consent in writing by the auditor, including details of beneficial ownership of shares. And when you've assembled all that, what do you do? Now, section 13.5 says that when you have done all that, the application for incorporation may be effected by one of 2 means. A, delivery of the completed application form as required. You send it to the registrar of companies. Or B, the delivery of completed application form as required, accompanied with the proposed constitution. Now, what this means is that if you are going to register with your constitution, then when you send the application The application must be accompanied by the constitution. So let's keep that in mind. So once you have submitted it, of course, you must also give the appropriate evidence of your identity. And thank God now we have the Ghana card. So we have a verified identity of almost everyone, as well as your location, that is where you live. That should all be, so your digital address here is important, isn't it? And of course, your TIN number. And except that the Ghana card now is also used as the TIN number for a lot of people. So you submit all that. Now, when you have submitted, you need a decision. And the decision will be either you have succeeded in the application, and for that matter, you get incorporation, which you apply for, or you have not succeeded, and for that matter, you don't get the incorporation that you apply for. So let's keep that in mind. And that is why section 14 says that where the registrar is satisfied that the application for incorporation of a company complies with this act, that is Act 992, the registrar shall, after payment of the prescribed fee, certify under the seal of the registrar that the company is incorporated. And in the case of a limited liability company, that the liability of the members is limited. Now, the import of section 14.1 is that the registrar will vet the application and make sure that the application is in strict conformity with requirements of 992 as well as laws of Ghana. And particularly so, if let's say that you have proposed maybe a particular name which you want to use, and maybe the registrar is of the view that the name that you are using, for example, is inappropriate, so change it. Otherwise, you will not be incorporated. You can refuse the incorporation, or, I mean, just as if you look at the, if you look at the English case of R against Registrar of Joint Stock Companies, ex parte more, a very interesting case. Someone applied to form a company. He was going to use it to sell lotto tickets in the Irish lottery. And the registrar refused because, according to the registrar, lottery was illegal in England at that time. And for that matter, it was not acceptable. Now, the decision was challenged in court, but the Court of Appeal, the English Court of Appeal, agreed that the registrar was right in refusing to register the company. Because as at that time, as I said, this was a way back in the 1930s. Lottery was still illegal there. So, but then where the registrar has satisfied himself that everything is in order, he will now issue the certificate of what? Incorporation. So if you look at section 14.2, that from the date of incorporation, the company becomes a body corporate by the name contained in the application for incorporation, and subject to section 13 is capable of performing the functions of an incorporated company. So the company is officially born when the registrar has certified under his seal that it is incorporated. And from that moment onwards, it is a legal person. It is a juridical person. It can enter into transactions and it can sue and be sued, as we'll discuss under the theory of incorporation and its consequences very soon. Good. So the registrar must give evidence of his decision that he has actually approved that the company should be incorporated or should be formed. So that evidence which he must give of his decision is what we call the certificate of incorporation. So if we look at section 15 of Act 992, we are told that the certificate of incorporation or copy of that certificate, certified as correct by the registrar, is conclusive evidence that the company has been duly incorporated under this act, and proceedings shall not be brought in the court to cancel or annul the incorporation. Now, this provision is very important, and I'll draw your attention to something. It said that the certificate of incorporation is a conclusive evidence that the company has been duly incorporated. Now, in law, we have what they call the conclusive presumption and then rebuttable presumption, or conclusive evidence and prima facie evidence. Now, conclusive evidence, as the word suggests, conclusive means that finality, isn't it? That is to say that the evidence is final. It says what it says. So it says that all that needs to be done before a company is registered and incorporated were done. So there should be no occasion for anybody to go to court and say that this company should not have been registered because a subscriber did not sign the application or this person didn't do that. No. The lawmaker wants to avoid unnecessary disturbance of the company when it is up and running. And that is why it says that insofar as the registrar of companies has come to a firm decision that, in his view, the company is duly incorporated and issues certificate of incorporation to that effect, that settles all. And nobody should challenge anything regarding the processes leading up to the incorporation. But there is an exception to that rule, that the certificate of incorporation is conclusive. And for that matter, no one can bring an action to challenge it. So if you look at section 16, section 16 of Act 992 makes the point that that principle, which we stated, does not, under section 15, does not preclude the institution of proceedings to wind up the company in accordance with section 274. There are permissible instances in which the company may be wind up, which section 274 has actually alluded to. Now, that one is different from what we're talking about under section 15. So let us keep that in mind. And later on, we'll discuss what they call the corporate insolvency and the restructuring. And you notice that among other things, there can be official liquidation, even at the instance of the Attorney General or anybody within any of the permissible grounds. But as I said, when we get to discussion of the corporate insolvency and restructuring, we'll discuss more of section 274 as amended. Now, what about if there was an error or omission in the document submitted for registration? Because remember, section 15 has told us that once the certificate of incorporation has been issued, it signifies that there has been due incorporation. That is, all the requirements, the due process, which needs to be followed before we have incorporation, were actually followed. But if there's an evidence that, as a matter of fact, there was an error, there was an omission in any of the documents, what happens? So section 17 speaks to that and says, and I quote, where there is an error or omission in a document, containing particulars delivered to the registrar under Section 13, the company and every signatory of the document is, without limiting Section 3, 4, 6, liable to pay to the registrar an administrative penalty of 150 penalty units. So you see how the lawmaker is trying to balance the situation. Because what we are witnessing is that, on the one hand, we do not want a situation where a company which is incorporated and is running business is saddled with legal proceedings by someone saying that certain things which ought to have been done as part of the process for registration were not properly done. And for that matter, the incorporation is invalid. It should be declared null and void. Now that will bring unnecessary confusion. So the lawmaker needs to deal with that. And that is why Section 15 says that certificate of incorporation is a conclusive evidence of due incorporation. But it is also possible that, as a matter of fact, someone did not do things properly. Maybe there was a material omission of a certain information, or there was maybe even an error in certain information provided during the application for incorporation. And that is why Section 17 says that anybody who was responsible for that, who signed a document knowing that the document contained an error or the document had omitted the material information, will have to suffer a penalty, which is payment of money, which will be levied by the registrar of companies, and you can be made to pay 150 penalty units. So let us keep that in mind. In addition to other criminal offenses or which may be brought against you. Because if we go to Section 346, right, it is an offense to be using the word incorporated or limited and so on when you have not gone through proper processes. So therefore, where you sign documents for incorporation knowing very well that there are certain key omissions or errors, you bring yourself within the consequences or the sanctions prescribed under Section 346, as well as the one prescribed under Section 17 that we have just discussed. So let us keep that in mind. Good. In absence of any question, we will continue, and we are going to discuss the legal consequences of incorporation. What is the legal effect of incorporation?
Yes, sir.
Yes.
Yeah, so I have a question.
All right.
And my question relates to Section 1D of the Act 992.
1D.
And yes,
okay.
Section 13D.
13.
It's
13(2)(d).
Okay, sorry, 13(2)(d). Sorry, sir.
Okay.
So yeah, so I quote: the address of the proposed registered office and principal place of business. My interest is on the principal place of business.
Okay.
My question is, if I register a company using a principal place of business, is it transferable? In other words, if I did it as it sometimes, and at a point in time I want to transfer the business to Atasomaso, can that be done by law?
Oh, why not? It can be done. All that, there's what you call the annual returns, and so when you submit your annual returns, all these material changes, or sometimes you may even have to file a dedicated process to bring it to the attention of the Register of Companies that these are the changes which are being made. So that can be done. Except that anytime there is such a change, you must go to the Registrar of Companies and update it so that the records there will reflect what is on the ground.
Same.
Yeah, because mind you, anybody at all can go to the Register of Companies and conduct a search on your company without even you knowing about it. And when he goes there, the information there is supposed to be the true information.
Thank you, sir.
Okay, so now let me give you 5 minutes break and then we will continue. 5 minutes break and then we continue.